Rule 49 and Rule 2 speaks of
series of acts of omission.
2 or more crimes may be joined in one indictment if the series of acts committed together form the same transaction. I must state that in recent days, since this has been a topic on the agenda, I have looked at the 3 versions of the indictment, of the Kosovo indictment, and nowhere, in no place, did I come across any mention made of the fact that everything that took place in Kosovo was done with the aim of creating a greater Serbia. That is such an absurd assertion and ludicrous attitude, and I apologize for using those terms, but I can say none other than that, that quite simply I cannot believe that something could have been uttered where we have an incontestable fact. Your Honours, you yourselves have already raised all those questions, and that is something that must be dominant when you come to deliberate and decide. I do not see, on the basis of what position of this kind could have been put forward at all or founded at all, and that in the case of Kosovo, that everything that took place in Kosovo took place within the frameworks and composition of an intent to create a greater Serbia. It is not, we are not challenging the fact, we are all aware of the fact that Kosovo is part of Serbia. Kosovo is the territory of one state. Kosovo, being what it is, has been what it is since the London Peace Agreement in 1913, not to mention centuries ago. I know why insistence is being made on the previous 10 years and the historical and political background of those 10 years. But when you come to deliberate and make your decision, I'm convinced that this trial chamber quite certainly will be interested in looking at a longer period of time, further back, and look at everything that happened in those areas of the former Yugoslavia and Croatia, in Bosnia, and most especially in Kosovo. And I assume and I hope that this trial chamber and this court will have the wish, perhaps through expert opinions, the opinions of expert witnesses, to hear something else and to hear about the whole historical background. I'm not going to enter into any polemics with the prosecution at this point in time, but let me just start out from passages from the indictment, and then we will come to the conclusion, we'll be able to come to the conclusion that there is a great deal of contradiction when it comes to this intention of creating a greater Serbia, which should be the cap for all of this, and which the accused is being charged with in these indictments. If you take a look at what we have already heard today and count 6 of the indictment for Croatia, it says that the aim is that parts of Croatian territory become parts of the new new state under Serb domination. Now, Croatia, has not been challenged. In the former Yugoslavia, it was a republic of that one and the same state and country, and later on it became a full-fledged state. The same holds true for Bosnia. But if you pay attention to what it says in the indictment for Kosovo, you will be able to see that the goal and purpose of those activities is to ensure control of the Serb authorities over that territory. I think that is quite logical. It is logical that in a state, somebody must ensure control over its own territory. But I draw your attention to another point we did not hear from the prosecution this morning, which is stated in paragraph 93 of the Kosovo indictment, where it states that this stepped-up control was done in the presence of a campaign of armed uprising and resistance to the Serb authorities. Therefore, something that does not exist anywhere, either in Croatia or in the Bosnia indictment, but it is present in the Kosovo indictment, and that is diametrically opposed. It is a great difference, an immense difference, and I think that this must needs eliminate the thesis according to which all these events come under the cap of the intent to create a greater Serbia. I don't have to speak about that at length, but I would just like to add two more elements. The time lapse that we have heard, and also something else during the Kosovo events, the accused Milošević did not have de jure authority and competence in relation to what was going on there. And under those circumstances, the circumstances of an armed struggle, an armed uprising, and the circumstances of the NATO bombing that we heard about this morning as well, and in respect to Kosovo and Bosnia, and most especially to Croatia, he did not have de jure competence. He had de facto authority and competence. So these elements, along with what I said a moment ago, will truly bring you into a situation where you will have to give careful consideration to whether all this can be joined, in fact. Of course, the best thing would be if faced with a situation of this kind, and you have not had a case before this tribunal, a similar case, if you could find a solution and solve it together. But if we were to join the indictments, and if we are only ready to go ahead with trial for Kosovo, as the prosecution has said, then you will have to think about the idea of Greater Serbia from behind. You'll have to start with Kosovo, and then you'll have to proceed along those lines. And this will lead you astray, I'm afraid, because the prosecution in paragraph 20 states that there were successive conflicts. It speaks of successive conflicts, and successive conflicts can never go from back to front. They can only go in the logical direction and in no other way. I don't know how you are going to decide what your decision and ruling is going to be. I was just duty-bound to point out these matters to you. Let me state again that the situation is a highly delicate one. It is a highly delicate situation, and if we were to view it from the aspects of judicial economy and only bear in mind the interests of the victims, of course we all have to bear that in mind. That is quite logical. We must take care of the victims. But this is a trial, this is a case in which we will have to clarify some vital interest points, whether there is criminal accountability in the sense that it was written down in the indictment, and then go on to thinking about all the rest. If I were defense counsel, I would know what to suggest and put forward to the trial chamber, but I am not the defense counsel. I am sure you will give great thought and deliberation in arriving at your decision faced with a situation of this kind. Thank you.
Thank you. Mr. Milosevic, this is a motion, as you know, that all three indictments should be joined together. It's your opportunity to address us on that, if you wish.
All that we heard today from the so-called prosecution only confirms that the whole concept is misconstrued. But so that you don't deprive me of the floor, I will stick to only those arguments that are in response to your question. For me, it is quite clear why this false prosecution insists on a joinder. It is a consequence of the 11th of September. They wish to place in the background the charges for Kosovo, because those charges of Kosovo inevitably open up the issue of the cooperation of Clinton's administration with the terrorists in Kosovo, including the bin Laden organization. Secondly, what we heard today shows that they too are aware that in that case they cannot avoid, regardless of the illegality of this tribunal, of the main protagonists of the crimes committed against my country and people appearing here, starting from Clinton, Albright, Clark, and others, but of course also many peace mediators whose activities and cooperation in finding peace absolutely denies what I would call monstrous allegations uttered here. Therefore, their reasons are of a completely pragmatic nature, designed to protect those who committed crimes against my country, rather than any reasons of judicial economy, because they certainly don't care whether I will be fatigued or not. I've already said what I think about that. As for the Crown argument that has been set forth here, the idea of the creation of a greater Serbia, that is an argument that can easily be disproved, and I don't think that anyone with any sense could use that argument, which they have used as a thread and basis for all crimes, to continue to impute, impose, or in any other way abuse it. There are certain indisputable facts. On the 28th of April, 1992, the Federal Republic of Yugoslavia was established. On the 28th of April, 1992, therefore, before the conflicts started, before the civil war started, the Constitutional Assembly, by its official document, declared what our position was, and it said that the Federal Republic of Yugoslavia has no territorial pretensions towards any single one of the former Yugoslav republics. That is absolutely sufficient proof that this nonsense that is being alleged be absolutely rejected. I should also like to recall that at the very beginning of May 1993, thanks to our maximum efforts in Athens, the Vance-Owen Plan was accepted and signed at the time by Serb representatives as well, and that acceptance was prompted by the belief that peace was the greatest objective and value of all the Yugoslav peoples, and that very fact denies any such idea. Also, life in former Yugoslavia during those 10 years best disproves allegations about ethnic and religious discrimination, because the Federal Republic of Yugoslavia is the only state which has preserved its multi-ethnic character and in which there was never any discrimination on national or religious grounds. The 10 years behind us confirms this. The same applies to Kosovo. Perhaps you do not know this, but the government of the autonomous province of Kosovo and Metohija in 98 and 99 during the war, throughout until those who committed aggression set up their agents in Belgrade, was composed of Serbs, Albanians, Muslims, Turks, Goranci, Romanis, and Egyptians. The Serbs were in the minority in that government. So how can this idea of national discrimination be reconciled with this fact? Our delegation in Rambouillet also was composed of representatives of all those ethnic groups. How can that be reconciled with these monstrous allegations of ethnic discrimination. Do you know that in 1998, after 10 years of peace in Kosovo, 10 years when no one was killed, and during those 10 years no one was arrested, and tens of newspapers were published in Albanian that were on sale at every corner, and there was education in all elementary and secondary schools in Albanian. And after 10 years, when terrorism escalated, organized by foreign services from the remnants of the Albanian mafia, we set up police in Albanian villages by these villagers themselves, selecting policemen who became armed, and they were Albanians, as were the postmen, as were the forestry workers, as were the other officials in the state administration. They were the target of assassinations, slaughtering, killings by Albanian terrorists. In 1998, there were more people of Albanian ethnicity that were killed by Albanian terrorists than Serbs killed by Albanian terrorists. A particularly eloquent factor is that in all our bodies, even in our Socialist Party, the membership reflected the composition of the population. There were Serbs and Albanians and Turks and Hungarians and Ruthenians and Bulgarians and all others. Who would have thought of supporting a program of national and religious discrimination that is being alleged? These two indictments for Croatia and Bosnia have been explicitly issued precisely to drown the indictment for Kosovo, which is evidence of terrorism, though it is quite clear that both in Croatia and Bosnia we advocated peace and not war. We assisted our people to survive and not to become a victim of genocide as it had been during the Second World War. But on numerous occasions and in public, we stated, and I among them, that we wanted those people to be free and equal in the territories in which they live, but not at the expense of any other people. The example of the Federal Republic of Yugoslavia and very good interethnic relations throughout the time of conflict best illustrates this. During the conflict in Bosnia, not a single Muslim was expelled from Serbia. During the conflict in Croatia, not a single Croat was expelled from Serbia. Even during the time of conflict in Bosnia, look at the records of the UNHCR. More than 70,000 Muslims of refugees found shelter in Serbia. Then who would be those people, those thousands of people who would seek shelter from the people who had committed aggression against them? Do you know that there are more Muslims living in Serbia than in Bosnia and Herzegovina? The Muslims in Bosnia and Herzegovina have been pushed into this tragedy, into this war, so as to be subsequently supported and to have an alibi later for killing millions of Muslims all over the world in accordance with the interests of those in power, with the aim of enslaving the world and colonizing it. Particularly, I cannot understand that someone can have the gall to talk about Kosovo as something not being a part of Serbia. Kosovo is Serbia, and Kosovo will remain Serbia. And this situation will last only as long as this illegal occupation of Kosovo and Metohija continues. Illegal because it came about through the abuse of the United Nations and Resolution 1244 of the Security Council, which envisages the presence of UN security forces there. However, those forces have usurped the authority of the United Nations and allowed continued terror by Albanian terrorists, so that thousands of Serbs and other non-Albanians of Kosovo have been killed and kidnapped, tens of thousands of Serb houses burned down, more than 100 churches have been destroyed and burnt. All this under the auspices of the international forces who came there to guarantee safety for all. And today, after these distorted elections, when Serb deputies go under military escort to enter the so-called parliament. That will continue for as long as the occupation continues. That was the situation that we had during Turkish occupation for 500 years, but this will not last as long. And when that occupation ends, Kosovo will again be under Serbian control. Not only Kosovo, but also Serbia, because Serbia will again and shortly be run by patriots, as will other countries, instead of this new strategy of a neo-colonialism and the appointment of various puppet governments. I think that everything we heard today, and which is on a total collision force with the truth, has shown to what extent these indictments have missed their mark. I can only understand them as an expression of fury and revenge for the fiasco that NATO experienced in its attempt to impose military occupation of Yugoslavia. And I must tell you that I am proud to have been in command of the armed forces of Yugoslavia that halted NATO, because we have proven that even a small country that has a firm will to defend its freedom and to defend the idea of freedom and equality of nations and people can defend themselves. This is punishment because we oppose the danger of the greatest tyranny threatening mankind. And the various things that can be found in these indictments are the remnants of a media war designed to satanize the Serbian people, the Serbian leadership, myself and my family, because the media war came before the real war, and the aim was to persuade public opinion in the West that we are evildoers, though we never gave cause for such accusations. You read out today that on the 6th of April 1992, the European Union recognized Bosnia and Herzegovina. This was done under the influence of the then Minister of Foreign Affairs of Germany, Genscher, because the 6th of April is the day when, in 1941, Hitler attacked Belgrade.
The
desire was to symbolize a change of the outcome of the Second World War. I would never attribute that to the German people, but some statesmen have kept alive the evil that we fought against together, and they have achieved more than a revenge, because they have managed to kill us with the hands of our allies, the Americans, the British, the French, with whom we fought together during 2 world wars against that same evil.
Mr. Milosevic, you've had some time. You're getting somewhere from the issue which we have to determine here, which is this, whether these 3 indictments should be joined together. Is there anything more you want to say about that particular issue?
I have already told you what my position is towards this tribunal, though Judge Robinson says that that has no consequences for you. Therefore, what you will do is up to you. I'm just saying that not a single argument that has been set forth here in favor of some kind of joinder is not truthful, it doesn't stand, it is not correct, and has no justification whatsoever. Therefore, the arguments are false, as are the indictments. And you will decide as you see fit. That is up to you. I think that the arguments offered are against the idea set forth by the prosecution, because all that they have said, and that as they move forward, it'll become clear on what shaky legs this whole thing stands and how it is based on a media war and not on real facts, especially facts that could have any weight. And the fact that their language and the structure of their submissions fully coincide with what we have been listening to for 10 years in the political pamphlets appearing in the media only shows that they have been compiled at the same source. If I were in your place, I personally, regardless of your status, which I am denying, as you know full well, I would reject such ideas. They simply wish to push into the background Kosovo only because it raises the issue of cooperation with terrorists, and it is not suited to current policies. They are ready to falsify historical facts for the benefit of daily politics, and that is something that even this illegal court should not allow itself to do.
Mr. Nice, very briefly, please.
Yes, but there are one or two important points if I can deal with them. Mr. Kay's argument about the way that the rule should be construed, which in a sense supports joinder, I make this point. When each of the indictments was confirmed, the confirming judge no doubt considered and found that constituent crimes, different though they are one from another, constituted a single transaction. When you have the same mix of different crimes, it's true, currently in 3 different packages, then there is great strength in the argument that follows from Mr. Kay's interpretation, that they similarly form part of the same transaction. They've already been found in this admixture to be the same transaction once, likewise twice. I agree with the intervention of His Honour Judge Robinson about the breadth of the practice, and on that point I would simply repeat what's in the, not repeat, remind you of what's in the motion about the practice in this very court where there are politicians on trial. The material is indeed what it is you've got to look at. The material does support the argument, and indeed that's why I drew your attention in the motion to the 3 particular passages in the 3 particular indictments. But can I draw your attention to something you may not have before you? I can read it out, it's very short, but it's important. And this is in the Kosovo pre-trial brief. First of all, on page 9, at paragraph 23, dealing with the earlier Kosovan problems in the 1990s, there's this passage. In the early 1990s, the possibility of the situation escalating to armed conflict appeared very real. The accused had already demonstrated in Croatia and Bosnia and Herzegovina that he was prepared to go to war to achieve his vision of the greater Serbia. The seriousness of the situation in Kosovo prompted the United States, and then we come on to the warning that we say simply led to delay of the crime that was committed in 1999. In that same pre-trial brief, at page 48, paragraph 113, dealing with the events in 98 and 99, we again observed that the activities there were consistent with the criminal activities of the accused in Croatia and Bosnia during the early 90s. So that the matter has indeed been in our minds and has been canvassed throughout. My learned friend, Mr. Reinveld, tells me, in contravention to what the accused has just said, that he announced an intention to join in August of this year before September. One other point arising from what my learned friend the Amici have said, when they speak of 3.5 years, and I spoke of of judicial economies of scale in my motion. 3.5 years for separate trials. For the reasons we've advanced, we would invite you to say there are true judicial economies of scale with one chamber hearing all these things. The ability to make proper but radical decisions about what evidence is required and how evidence is to be given is going to be far, far greater, and the savings far greater, in the event of a single trial. Mr. Tapuskovich, a couple of points from what he said. He challenged the notion of the Greater Serbia, as I've sought to make plain, although it appears in the terminology generally, and we refer to it only with caution. It's really the Greater Serbia versus the new Yugoslavia as a term to reflect Serb-dominated state. And it was interesting to observe that the accused, in speaking to you just now, and helpfully, made it quite plain that so far as he is concerned, Kosovo will come under Serb control again. It is the same principle. And of course, what we know from the papers that are before you is that what led in part to the breakup of the old Yugoslavia was the reduction of autonomy of this state, barring their rights to autonomy and existence. And it was that, of course, that led to this particular conflict. So Greater Serbia is, as I've said already, but I must repeat, not creating something larger. It's retaining and or incorporating relevant parts of other territories. So far as the defendant himself, and I won't deal with the political points because I forecast that your honours wouldn't wish me to, as to territorial pretensions, that's covered in the papers, and it will be entirely a matter for the Chamber to decide in due course. As to the suggestion that what happened here in relation to indictments about Croatia and Bosnia was all done simply because of what happened in Croatia. Of course, that is simply untrue. These matters had been under investigation way before that event. But the court may notice that which I forecast earlier this morning, that whichever one of these trials is being dealt with, the defendant is going to be advancing a single theme. Now that, of course, in itself doesn't make a single transaction out of something that might not be. That's a general proposition. But one can see, first, that if we have the Kosovo trial first, and if his attitude towards these issues remains the same, we are going to have all of the previous events trawled through, as I suggested. And before we ever get to those earlier events, the court will have had to make decisions about these later events, which will be hopelessly confusing, I respectfully suggest, for any court dealing with these matters. It was his argument a reinforcement of the huge practical desire to have all these matters dealt with in one. And the court will remember, I hope, that in my motion I said there are advantages to both sides. It's balanced. And one of the advantages was the advantage that would go to the defendant, who obviously seeks to show that everything we are doing relates to Kosovo. If the indictments are joined, he'll be in a position to raise those matters and won't have to incorporate them or get the evidence in or seek to rely on that which is not primarily before the court. So that in our respectful submission, everything that he has said not only confirms that which the court may have inferred is in the mind of many people in this court, namely that a single trial would be much more convenient, although large, much more convenient, and will bring true economies of scale. But everything that he said shows that from his side, this is a single transaction. And although that cannot make good what isn't, in our respectful submission, it fits with what we say, which is that things are entirely different in interpretation from the way the accused has represented them to be today. But they are a single transaction, reflecting his overall plan, internal, personal plan of keeping power and of keeping power for a particular format of Serbia.
Thank you. Yes, we'll adjourn now for half an hour. We'll consider these matters.
All right, veuillez vous lever.
The trial chamber has considered this matter, and we give this ruling now. Our decisions will follow in due course in writing. The prosecution motion is allowed to this extent, that the Croatia and Bosnia indictments will be joined. However, the Kosovo indictment will not be joined, but will be tried separately and first, beginning on the 12th of February next year. The pre-trial conference will be held as arranged on the 9th of January. And as I say, our reasons will follow in writing. Now, there is time to raise any other issues which the parties wish to raise relevant to these proceedings. We'd be grateful if that could be dealt with as quickly as possible, given the hour. Prosecution first.
Our only immediate and pressing concern relates to Rule 68 disclosure. So far, I think Your Honour is the pre-trial judge in respect of Kosovo and Croatia. We have yet to discover who will be appointed in respect of the Bosnian part, but presumably it's likely to be Your Honour, because you're already seized of Croatia and the two are now joined.
I think that's likely.
The court has not announced which chamber is to try the following trial, as things are ordered to be disposed of by this chamber.
The same trial chamber.
Very well, that's very helpful. It would, I think, be helpful if we could have a hearing under, as it were, 65 ter before the pre-trial judge, effectively, Your Honour, to deal with Rule 68 in respect of all three matters. And as I indicated in the course of argument, I will have prepared before that meeting an extensive analysis of where we are in Rule 68 disclosure practice and development, in order that we can satisfy the chamber, not that we're under an obligation to do ahead of events, but we can satisfy the chamber of what we are doing, get assistance from either the chamber or from learned friends, the amici, in relation to what we're doing, and so that we can the better inform everyone of the likely timescales involved in Rule 68 disclosure according to different criteria. That's what I wish to do. Of course, a 65 ter hearing is, I think, nominally one which involves the parties, and for these purposes the parties doesn't actually include the amici, but should include either the accused or his lawyer. The accused not being represented, it would have to involve the accused himself, and we would have no objection, of course, to the amici being present, subject to any observations that the accused himself might make.
I think the difficulty is the timing, the recess beginning next week.
might it be possible to have such a hearing, if not before, then on the same day as the pre-trial conference in the Kosovo case?
Is there any reason why it shouldn't be part of the pre-trial conference?
Well, as it's the same trial chamber, no reason at all.
That might be a convenient way to deal with it all.
And I'll get a report on what we're doing before you and served on the defendant, the accused, I beg his pardon, and the amici as soon as I can before then.
Yes, that would be helpful.
I can't immediately think of any other issues that are arising at the moment.
Thank you.
Nothing occurs to us at this stage, Your Honour. And the trial date being 12th of February for Kosovo is very helpful, as we know what target we have to work to.
Yes, it did appear there might have been some problems about disclosure, but it may be that you and the prosecution can work on that together.
Yes, we have made a schedule of supporting material served, as well as incorporating within that schedule the identities of those in the summary of their evidence, and pointed out where we don't have statements of those within the summary supplied by the prosecution, and where we have statements within the supporting material of those who haven't been included in the summary. It may be that there's a translation blockage which has prevented statements from being released, or it may be that some of those witnesses are to be dispensed with. We don't know, but we did want to have identified, and it might well be helpful for the court to be in the same position, so that witnesses that are going to be relied upon, so that we don't waste time reading statements of witnesses that are not going to be used in the trial. I don't know whether the court was alert to that problem at the moment in relation to the material, but we've served it on the prosecution today. It's a schedule that Mr. Nice referred to this morning, and I understand it's being reviewed and looked at.
Apparently the matter will be dealt with at least by the end of January, so we were told.
Yes, as far as we know, by the end of January, it's a question of getting the translated documents, the documents to be translated. Very helpful to have the schedule. The matter will be considered, and we'll make sure that there's nothing that we've overlooked that we shouldn't have overlooked.
Thank you. Yes, Mr. Vladimir.
Yes, and may I add that the amici are available to the pros to help them out to identify the criteria for exculpatory evidence for their search.
Thank you. Mr. Milosevic, there's one matter we want to raise with you. It's this. You haven't appointed counsel to defend you. As you know, it's your right to defend yourself if you wish, although you may wish to reconsider that in the light of the complexity and seriousness of these charges. But that's a matter for you. Meanwhile, we would wish to have this made clear. In the preparation of your defense, do you wish to have legal advice? And if so, from whom? I say legal advice, and would add this: legal advice or any other assistance. Now, would you deal with those matters? Do you want legal advice? And if so, from whom do you want it?
I have been informed in the meantime that without my request, you have assigned certain advice that I did not ask for, interpreting my agreement to receive visits by certain individuals as a request for legal advice. My response to that has been addressed to the registry that I do not consider that whoever visits me and has a law degree should be appointed as my legal counsel. And I don't think it would be permissible for visits to continue to be restricted, visits by persons who wish to visit me in accordance with the rules that you have established and on a non-discriminatory basis, since other people in that prison are allowed such visits. Secondly,
if you don't want advice from Mr. Clark and Mr. Livingston, which we understood you did, who do you want it from?
No, I'm not asking for any advice from anybody. I have said that I would like to be granted the possibility to be visited by people who wish to visit me. That's all. Secondly, I have heard here that you have an infrared camera in my cell. I was informed by the detention administration that the light has been switched off because the camera has been switched off, but I haven't been informed that this light that your spokesman mentioned has been switched off, and I request that it be switched off as well.
We'll look into that. Now, Mr. Milosevic, is there anything else you want to raise? Very well. The trial chamber will adjourn until the 9th of January.
All rise, veuillez vous lever.